Welcome to Court Helicopter Explainer, where we are dealing with a very contentious issue. The Law Employment Act says you work for 6 days, 1 day to be an arrest day. Members of the Seventh-day Adventist Church rest on Saturday. So, can an employer force members of the SDA Church to go and work on Saturday? What is the position of the law? Remember, Article 32 talks about the sanctity of religion. So this question was put before the court. That is the case number 1620 of 2018 before a judge of the High Court of Labor in Nairobi. The brief facts of this matter is that this claimant was working in a hospital for very many years, and she always negotiated for her not to be allowed to work on Saturday. But the employer refused and said, you cannot direct the employer on which day you work or on which day you don't work. So the question before the court was, can you be forced to work on a day you say is your day of worship, is your day of the Lord? What did the court say in this? What did the court say? This is the decision of the court. Based on the foregoing analysis, I arrive at the conclusion that the respondent has not established that it had valid reason to terminate the claimant's contract of service. Accordingly, I declare the respondent's decision to terminate the employment contract between the parties unlawful. 2. The evidence on record demonstrates that the respondent discriminated against the claimant on account of her religion. The respondent paid lip service to the claimant's freedom of worship by demanding that she works on some Saturdays, despite acknowledging that Saturday was the claimant's worship day. Yet the respondent protected Sunday as a rest day for the benefit of other employees whose worship day was on Sunday. Accordingly, I declare the respondent's handling of the claimant's worship day as discriminatory. I also declare the conduct of the respondent in this respect as a violation of the claimant's freedom of religion. What is the judge saying? The judge is saying employers set Sunday for their employees to go to church, but they don't allow those who worship on Saturday to go to their church. And the court found that as a complete violation on the right of freedom of worship. The judge goes on to say, out of this, the judge made this pronouncement. The compensation, the claimant has also claimed for compensation for unfair terminations. As I have observed in the preceding parts of this decision, it is clear to me that the respondent not only terminated the claimant's employment without valid reason, but also violated the claimant's freedom from discrimination and freedom of religion. The circumstances leading to the claimant's termination were necessary, harsh, and disrespectful of the person. I consider that an award of compensation equivalent to the claimant's gross salary for 12 months is fair in the circumstances. This works out to 2.5 million shillings. In rendering this award, I've also considered the fact that there is nothing the claimant's conduct that could legitimately be said to have contributed to the respondent's apparently harsh reaction. What is the law here? For the employers, you have got to respect the freedom of religion of your employees. This one, if you force a religious person who is telling you they are going for a religious festival, then you have an issue. We are heading to Easter, the holiday of Easter. it is a religious holiday. Can you force your employees to work? You cannot force the employees to work on Easter. If you force the employees to work on Easter, then you will find yourself having a problem with the law. Can you force employees to work on Christmas? You cannot force anybody to work on the 25th of December because that is the day of their religious festivities. So you know, avoid these issues that we are dealing with you on it. The second case we are looking is the case about constructive dismissal. Constructive dismissal is a question where somebody, the employer, will force you to resign. You don't want to resign, but the environment is so toxic. You are being given warning letters every day. You are being summoned to show cause letters. You are being shouted at. You are being told. You are being dressed down. You are being comments that are demeaning until you resign. If an employee proves that the environment was made toxic, the courts have found out that that is constructive dismissal. Another reason, another ground for constructive dismissal is you are in a WhatsApp group of the office. All of a sudden, you find that your name has been, you are no longer part and parcel of the WhatsApp group. If you find that your name has been removed from the group, office group work, that the courts have made that is constructive dismissal. Another issue about authority is the manner in which disciplinary procedures are communicated. This was the issue in a case where the case of E152 of 2023, where an employee was dismissed and the letter, before she received the letter, the employer posted on the Facebook. The employer put that message on his Twitter account. The court has found out that if you are being sacked, before that information is made public, you must be given the letter. Remember, it is the same even when people get accidents and they die. You saw when the death of the MP for Emurua Dekir, everybody suspected that he has died, but until the family was informed, that information could not be made public. When Raila Odinga died, that information had to be kept until the family had been informed. So under Employment Act also, any disciplinary process, if you publish this as an employer on your Facebook before you give notice personally to the person who you want to sack, the courts have found that completely unconstitutional. So now you know the two landmark decisions that have come, and also the other landmark decision where the courts declared that any probation, any employee who is on probation, once he is terminated, he will be paid as all those employees who have permanent job. We will be now answering questions, at least all the questions that come, we will be answering them in our episode that is following. Wakili Dan Sanomari, we appreciate you. Thank you very much.